All stand, please. Please be seated.
Yes, thanks, Mr. Armstrong.
Thank you, Your Honour. Now, Your Honour, I had summarised the facts as the plaintiff alleges them for the purposes of this proceeding. I should say plaintiffs. Of course, we bear the onus of proving them upon the balance of probabilities. That is to show that they are the probable explanation for the force of bushfire. As Your Honour knows, the defendant, Ms Barrett, does not admit the cause of the fire.
Duty's not an issue, though, is it? On the pleadings and in the opening submissions.
As we understand it, Your Honour, that's correct.
Mr. Reid nods. Thank you.
I'm not in agreement. It is not in issue.
Yes, thank you.
I'm grateful to my learned friend, Your Honour. Now, as I say, duty is not an issue, but the defendant does not admit the cause of the fire and does not admit breach. We apprehend that she intends to call witnesses whose evidence, she says, suggests an earlier fire or at least a second and unrelated fire. We say that the evidence that has been foreshadowed to us does nothing of the sort, allowing for the vagaries of people's recollection, both as to time and as to direction. All of the evidence points to the fire, as we allege it, from the tree stump and from Ms Barrett's property. So then the defendant has a fallback defence that was raised for the first time in her written outline of opening submissions that we received last week. She raises the possibility that even if the fire started from a smouldering root in the stump, perhaps that root had been smouldering since her last burning off fire in the stump back in September 2012, which of course was before the fire permit period. Now that would be a positive allegation from the defendant, Your Honour. It would need to be pleaded in her defence. It was not pleaded. It was not put to her expert witnesses, and it is not suggested or addressed by them. And we say it verges on...
This is a circumstantial case, though, isn't it?
It is, Your Honour, yes.
Isn't it therefore incumbent upon you to exclude any reasonable hypothesis?
As I said, Your Honour, we say that that hypothesis is fanciful. So yes, we say we do exclude.
Yeah, but I just want to avoid any pleading point.
Yes. The far more probable explanation, Your Honour, we say indeed it is the compelling explanation, is that the smouldering root resulted from the campfire 6 days earlier, not some burning off bonfire more than 3 months earlier. And as for the issue of the root identified by Mr. Thomas, the defendant's expert during his investigations, or his interpretation of some of the photos that Your Honour has seen and the other evidence from the fire investigators, that the root, as it was found and in its alignment to the extent that it had been turned into charcoal, it being perpendicular to the stump, nonetheless, Your Honour, we say that the evidence overall points to a fire from the stump having been the cause of ignition of this bushfire. Your Honour knows, or Your Honour will hear evidence from Mr. Anthony Butler from the fire brigade that he found a section of burning root close to the stump. We have the TFS investigators who identified the point of origin of the fire as being at the section of the root that they excavated back toward the tree stump. And Your Honour, somewhere in that area, in our respectful submission, the fire was ignited as a result of the smouldering burn in the root system, and there was no other plausible cause of this bushfire. Moreover, in our respectful submission, it is far-fetched in the extreme to suggest that the smouldering root had been smouldering without consequence and without giving any sign for over 3 months, rather than it being the result of the campfire on the 28th of December. Now, can I come to the allegations of law that are made by the plaintiffs? We allege that the conduct of Ms. Barrett amounted to the tort of negligence, and further or alternatively, the tort of private nuisance. Can I deal with negligence first? As Your Honour has just noted, the question of whether Ms Barrett owed a duty of care toward a class of persons in the position of the plaintiffs in these proceedings is not an issue. And we say, nor can it be. The risk that a fire ignited on the property or allowed to continue on her property in the conditions that existed on and between the 28th of December and the 3rd of January always created a foreseeable risk that if that fire happened to escape, then it could turn into a bushfire and extend over a wide geographic area. So the question of duty is not an issue in this proceeding. Rather, the first set of questions are whether that duty was breached. And the plaintiffs allege that the duty of care was breached in 4 respects. First, it was not consistent with the duty to take reasonable care to light the fire in the tree stump in the first place. The plaintiffs will contend that it is common sense that you would not try to light a fire in a bush setting within an old, dry, wooden receptacle. And especially, you would not light a fire in a wooden receptacle like a tree stump. Of course, a tree stump will still have roots to some extent. One does not know how far down or how far out those roots might go, or where a fire burning through the root system might travel. We say this is not just a matter of common sense. In Tasmania, it is the law under Section 69 of the Fire Service Act. If we are correct in our construction of the statute, then Ms Barrett and Mr Robinson broke the law in lighting the fire. And while there might perhaps be cases where conduct that contravenes a statutory norm is nevertheless regarded as reasonable, that is not this case. It cannot be said that it was reasonable in the circumstances of this campfire to disobey a requirement imposed by the Parliament of Tasmania for the safety of the people of Tasmania. The second allegation of breach is that Ms Barrett and Mr Robinson, as her licensee or invitee onto the property, failed to take reasonable care to extinguish the fire on the night of the 28th of December. Kicking some soil over it is not enough. If anything, that risks cocooning the fire, trapping the heat like a camp oven. And tipping 2 half buckets of water over it is not enough either. There is no assurance that the water will permeate the upper layers of ash to reach all of the sides of all of the coals, or get down into a root system that might have been ignited. The third aspect of breach is that we contend there was a lack of reasonable care in checking the fire the next morning. Your Honour may hear evidence in respect of what Mr Robinson told the police. What is clear is that Ms Barrett herself did nothing at all. If Ms Barrett seeks to rely upon some conduct of Mr Robinson as discharging her obligation to check the fire the next morning, we would say that Mr Robinson's own examination was not sufficient. He told the police that he inspected the fire pit and held his hand to it to feel for warmth, but the evidence will be, Your Honour, that that is not enough. One has to turn over the coals, disturb the ash, and keep checking until satisfied that everything in the fire pit is not merely not warm, but actually cold. Now, the fourth aspect of breach, Your Honour, is that we say it was irresponsible of Ms Barrett to fail to investigate the steam that she saw near the tree stump after the rain on the 1st of January 2013. In our submission, steam screams heat. It was days since the campfire, but there was still heat. Clearly there was something still burning, and we say it needed to be investigated.
Is there any scenario where you could fail in your cause of action in negligence, but yet succeed in your cause of action in nuisance?
Yes. May I deal with nuisance in a moment, Ron? The last point I wanted to make in respect of the nuisance, I beg your pardon, the negligence allegation, Your Honour, is to mention the issue of the non-delegable duty. That is, the evidence will be that Mr. Robinson lit the fire, and he apparently did some check of the fire pit in the morning after the campfire. But we say that Ms. Barrett does not get to deflect any liability onto Mr. Robinson, because he was, as I said a moment ago, a licensee or invitee onto her land, and they were dealing with a dangerous substance or dangerous activity, namely the lighting and management of fire in the Fawcett Hills in summer. We say that Ms. Barrett's duty of care was of the non-delegable variety, so that even if Your Honour were to find that factually it was an act or omission of Mr. Robinson that allowed the fire to start or to escape, Ms. Barrett remained under a duty, a personal duty, to take reasonable care to ensure that Mr. Robinson took reasonable care. And the evidence is that she did little or nothing to supervise Mr. Robinson.
Is that simply the Burnie Port Authority point?
Yes, right. Now, can I turn to the issue of nuisance, the second cause of action we allege, and address Your Honour's question. In our submission, Your Honour, the test for liability in nuisance is fundamentally different from the test for liability in negligence. Nuisance, as Your Honour knows, looks to the question of whether there has been an unreasonable interference in the plaintiff's enjoyment of interests in land. It's an old tort, it's archaic in many respects, but it is still the law of this country. In short, the focus in nuisance is the unreasonableness of the interference suffered by the plaintiff. The focus in negligence, as we've just discussed, is the unreasonableness of the conduct of the defendant. It's a fundamentally different tort.
But still, if all of the plaintiff's actions were reasonable, such that you failed in negligence.
But we say, Your Honour, that a failure to take reasonable care is not the litmus test, it's not even necessary for liability and nuisance.
Isn't it difficult to envisage an unreasonable interference, absent unreasonable conduct?
No, Your Honour, because the focus, it's really encapsulated in that sentence, Your Honour, that the focus in nuisance is the unreasonableness of the impact on the defendant, regardless of the reasonableness of the conduct of the plaintiff. The only role that reasonable foreseeability or reasonableness of conduct has in nuisance, in our respectful submission, is as a factor that might affect the court's conclusion as to whether the interference that's been suffered by a defendant is of the variety that would be regarded as an ordinary incident of having land in that neighbourhood.
Well, I'll be very interested to hear that argument, given that the Burnie Port Authority occupied 15 years of my life, and the original arguments that went to the full court and the High Court were authored by me. It seems to me you might be trying to claw a bit back.
Perhaps so, Your Honour. The law of nuisance, it may fairly be said, has not moved a long way in, frankly, the last 800 years. But
we are beyond Rylands and Fletcher now, and it seems to me it's almost strict liability if you say that any fire on anybody's land is an unreasonable interference and requires nothing else.
It's still very close to strict liability in our respectful submission, Your Honour.
Well, it's a stringent standard of care.
A very stringent standard of care. I was going to say to Your Honour that this particular question of the role of reasonable conduct or reasonable foreseeability on the part of a defendant and its significance for liability and nuisance is an issue that's currently reserved in front of the Court of Appeal in the Supreme Court of Western Australia in a case that's typically reported as Heritage against the electricity networks, a matter that I was involved in at first instance. Obviously, when that judgment comes down, it may
So we'll be of assistance on this point, you think?
Yes, but in the meantime, Your Honour, we will certainly be addressing Your Honour in detail in closing submissions on that very question. And our respectful submission is that as long as one bears in mind that the test in Nuisance is focused on the unreasonableness of the impact on the defendant, then the relevance of reasonable conduct on the part of the plaintiff really becomes just a consideration and by no means a conclusive one.
This didn't arise in Woodhouse and Fitzgerald, did it? Because it didn't arise on the facts.
No, that's right, Your Honour. I'll need to check that, but I think Your Honour is correct. So that, really, Your Honour, that was all I wanted to say in respect of Nuisance. Now, can I make some comments about the nature of the proceedings in the trial? We've already touched on them briefly. But it is important to record that the procedure that Your Honour's Court has adopted for these three proceedings is somewhat innovative, and it should be mentioned. As Your Honour knows, there are three proceedings being heard together. Each proceeding represents the claims of persons insured by a different insurer or group of insurers. In each proceeding, the insurer brings the action exercising its rights of subrogation to recover both the payments that the insurer had made to its insured, but also, in many instances, to recover from the defendants damages reflecting uninsured losses suffered by each of the insureds. So there are what might be called insured losses together with uninsured losses covered by the three proceedings. There are nearly 400 plaintiffs across the three proceedings. They are individually named as plaintiffs, so strictly speaking, this is not a class action of the kind now available in this court under Part 7 of the Supreme Court Civil Procedure Act. But Your Honour has made orders that permit these claims to be dealt with similarly to a class action.
Can you just remind me as we go of those orders? Because the only one that's in the court book is my order of 2nd September 2019. And that doesn't seem to me to go as far as you were suggesting before the break this morning.
I'll need to check that, Your Honour. I had thought that there was an order for the identification of separate...
I've asked my associate to look into it also.
Yes.
It may well be that there were some orders made by the associate judge prior to me becoming managing judge for these proceedings. But,
Your Honour, I may have misspoken. I'll check that and I'll correct it later.
But anyway, I would like to know precisely what I'm doing.
Yep, certainly, Your Honour. We'll clarify that.
But certainly all three actions are before me. There's a
Yes.
single statement of claim.
Yes.
There are some 400 plaintiffs. There is only one test plaintiff.
Yes.
In your written outline of submissions, I think you referred to 87 plaintiffs. Now, the 87 plaintiffs are those that are in the schedule to the writ in which Ms Daly, the test case
Yes.
plaintiff, is named.
Yes.
Across the three writs, yes, it is more like 400.
Yes, Your Honour is quite correct.
So that was just a slip of the pen. I'm not missing anything, and the statement of claim annexed to the schedule annexed to the statement of claim also reflects 400.
The statements of claim. I think,
Statements
yes.
of claim, yes.
Yes, I'm not sure if there was a single consolidated list of plaintiffs annexed to the statement of claim in any of the proceedings.
Yes.
I think again, I'll need to
So
check.
there
this
are
on.
three statements of claim, but it is a uniform statement of claim.
Yes, yes. It's in common terms. I'll come in a moment to our application to make some final amendments to the statement of claim, and those amendments really are directed at updating the particulars to make it clear that the test case plaintiff, Ms Daly, is the focus of this trial. But apart from that, I think Your Honour may be correct in that there was not actually an order for the hearing of separate questions in respect of the other 300-odd plaintiffs, but those actions are before the court.
All right. Well, we can sort this out as we go along.
Thank you, Your Honour.
But there is some importance to the nomenclature.
Yes.
When we come to judgment writing and final addresses and so on.
Yes, thank you, Your Honour. Now, lastly, just in this regard, Your Honour, I think Your Honour has received, although I don't think it's yet in the court book, a key issues statement that's been formulated by our learned friends and ourselves, which seeks to...
It wasn't in this morning's update.
No, as I said, Your Honour, I don't think it's been... I don't think it's been added to the court book.
And I'm not sure, I can just check the,
I'm told, Your Honour, actually it's now document 124 in the court book.
I see, because new documents are going to the end of the court book index. Yes. Well, in that case, then I see, yes, indeed, the proposed further amended statement of claim and further amended defence are also
there.
in the new document section of the,
Yes.
or documents added section of the court book.
Yes, and it's quite likely, Your Honour, that more documents will need to be added to the court book as the trial progresses.
Which I calculated, sorry to interrupt, about 1.8 gigabytes is the equivalent of 128,000 pages of text or 256 reams of paper.
Yes, yes.
Were all the documents
Were they
text?
also be printed? That's right, Your Honour, yes. So we're hoping, I've noticed that Your Honour does not have any paper really on the bench, and we're hoping that this process of running it as an electronic trial will be much more efficient for Your Honour.
Yes, well, no doubt from my point of view.
Thank you, Your Honour. Now, that deals with the structure of the proceedings, and we'll clarify that issue about how we apply the nomenclature as the matter goes forward. Secondly, can I simply note again for the record that, of course, the court has ordered that this trial be recorded and uploaded to YouTube on a rolling basis each day. This will allow the plaintiffs and the public to watch the trial despite the COVID restrictions and indeed despite the physical space available in the court and any court in the country, really. We understand that this is the first occasion on which this court has adopted streaming technology like that. Now, relatedly, as we've just discussed, this is an electronic trial. We will have hard copies of everything in the court book available for witnesses and indeed for Your Honour if at any point something arises that requires that to be made available to a witness, for instance. What we had in mind...
What about tender?
I'll come to tender in a second if it's convenient, Your Honour. What we had in mind in relation to the hard copies is, for instance, it may be convenient for a witness at some point to mark on a map, and then the marked copy might be separately admitted into evidence as the marked version of an image that would otherwise have been displayed on the court screen.
Might be an idea for us to locate a laser pointer to...
Thank you, Your Honour. We'll take that on board.
I think we may have one in the court. I'll make inquiries.
Thank you, Your Honour. Now, I should also mention that the court has ordered a protocol to govern the electronic trial, and I should record that the documents in the court book are under that protocol not in evidence unless and until they are referred to either in a party in its opening submissions or during the course of the trial. In particular, the purpose of that order is to ensure that Your Honour is not expected to look at anything in the court book unless Your Honour has been taken to it in the course of the trial. At the end of the trial, there'll be a consolidated list of the tendered material prepared, and that will form the formal record of evidence from the proceedings before Your Honour.
And that's what is proposed to be filed at the end of the trial?
Yes, Your Honour. Yep. Again, filed electronically, but it will be a list prepared by the parties in consultation with Your Honour staff.
About this, of course, but what do you propose for the marking, the notional marking of documents with exhibit numbers during the course of the trial for ease of reference for counsel?
That was my very next point, Your Honour.
Yes, thank you.
The protocol, as I understand it, is that during the course of the trial, reference to a document by its court book number or its Bates number will be taken as tender of the document unless objection is taken to it promptly. We don't anticipate that it will be necessary or convenient for Your Honour to give each document a separate exhibit number. The transcript will record what has been referred to, and the transcript list will be used as the basis for preparing that final list of the evidence that has actually been given to Your Honour over the course of the trial.
Do you literally mean the transcript list, or do you mean something in the body of the transcript? Because if you mean literally the transcript list, I assume that you've cleared it with the transcribing team.
Well, one would hope, Your Honour, that the transcript, the list of exhibits referred to at the end of the transcript each day should refer to the list of documents.
It'll refer to the court book numbers.
Yes.
Or alternatively, the Bates number within a court book number which contains more than one document if that occurs.
Yes. Yes, that's right.
Okay, well, that seems reasonable to me. It's unique and hasn't been done before, but there's no reason why that can't form the list of exhibits, and the exhibits themselves are filed at the end of the trial.
Yes.
Again, I'll hear Mr. Reid as to that.
Yes, and if Your Honour is happy with that course, then it will mean that when a document is referred to, in, for instance, the way I've been doing it in the course of the opening this morning, I won't say each time I tender that document. I'll treat it as tendered unless one of my learned friends indicates that there's an objection.
All right.
I must say, Your Honour, in my experience in other matters in other courts that have been run as electronic trials, that does involve a significant saving of time, and it produces a very reliable record at the end of which documents have actually been tendered, as it were, under that process. Now, next, Your Honour, is the question about some videos and the view that is proposed to be undertaken. Mr. Reid and myself have agreed on a trial schedule. Which
I've seen that, thank you.
Yes, it only goes through to the end of the plaintiff's case at the moment, and Mr. Reid and I will discuss the corresponding schedule for the defendant's witnesses as we get towards the end of the plaintiff's case.
And counsel will have noted that we're not sitting on Friday this week.
I think, Your Honour, will see that the schedule actually records that. Yes.
It says not sitting, I just wanted to make sure.
Thank
it
you,
wasn't a document prepared by somebody not you, or not known to you.
Thank you, Your Honour. Now, after the openings this morning, the parties proposed that Your Honour will spend this afternoon watching the video recordings of the interviews that the police conducted with Ms. Barrett. There may also be an issue about whether Your Honour sees the interview that was conducted with Mr. Robinson, but I'll leave my learned friend, Mr. Reid, to address on that. And then tomorrow, Your Honour has ordered that there be a formal view of various locations.
Can I just stop you there for a moment? Because that raises the question of evidence which may be admitted to Bene Esse, in which case it will be necessary for that evidence to be excised or redacted from the delayed webcast. So I think counsel will need to be alert to tell me when there is a point at which the webcast should be edited.
Certainly, Your Honour. We'll attend to that over the lunch and adjournment. And
well, it's just a matter of bearing it in mind on an ongoing basis.
Yep. Thank you, Your Honour. Now, back to the question of the view. Again, my learned friends and Mr. Cox and I have agreed on the list of locations that we think it would be of assistance to Your Honour to look at tomorrow. As I said before, there are considerations of topography and vegetation which we think Your Honour will need to understand in order to appreciate the significance of evidence that Your Honour will otherwise hear from witnesses. And so we propose to take Your Honour to a list of locations tomorrow so that Your Honour can see them. Now, may I say that allowing for travel time and roadwork delays, we expect that the view will really take up the whole of the day tomorrow. And so the court will not be sitting in Hobart tomorrow. May I say as well that having been to the property myself on 2 occasions and looking at the weather forecast for tomorrow, can we invite Your Honour to give consideration to bringing a car with a fairly high wheelbase? If Your Honour has access to a 4-wheel drive, that might be perfect, really. And also, I think there's rain forecast tonight or tomorrow morning, and so with Your Honour's leave, I think the parties would prefer to dress neat casual rather than in suits, and Your Honour might also wish to do so and to wear boots that are suitable for trekking over mud.
Thank you.
It's been pointed out to me as well that I'd probably be doing my stomach a favour if I invited Your Honour to supply a picnic lunch. Can I put in a particular request for Cornish pasties, but that might be putting the court's assistance at far too high a level. I say that entirely lightheartedly. Now, lastly, Your Honour, the question of the pleadings. The further amended statement of claim prepared on behalf of the plaintiffs has been added to the court book. The defendant has prepared a defence to the further amended statement of claim, and the parties exchanged those documents last week. There are no objections to the proposed amendments either way, and in a moment I will formally seek leave to file our further amended statement of claim.
All right, well, on my reading of the proposed amended pleadings, the suppression case has gone, Mr Reid.
That's correct.
Correct, yes. So the suppression case has gone, Your Honour, and as Your Honour knows as well, there was an agreement reached with the second defendant, Mr Robinson, as a result of which he is no longer a party to the proceeding. The remaining defendant is just Ms Barrett. Can I also just mention for completeness that there are some very minor outstanding issues regarding the status of a couple of the named plaintiffs. There was one company, for instance, that had been deregistered and needs to be re-registered in order to be able to participate in the proceeding. We don't need to deal with that today. We can address it at a time convenient to Your Honour. So, Your Honour, subject to...
So there hasn't been any substantial opting out to use it?
Yes, the class action term.
Yes.
No, Your Honour, all of the plaintiffs, either themselves or by their insurers, had given instructions to my solicitors to participate in the proceeding, and no one has withdrawn those instructions. So, Your Honour...
Anyway, they're things we can deal with formally at the end of the...
Thanks, Your Honour. So, Your Honour, may I formally seek leave to file the further amended statement of claim?
Yes, Mr Reid?
Yes, no objection.
Yes, thank you. Well, that can be filed.
If it please, Your Honour, and that is the opening on behalf of the plaintiffs.
Thank you. Well, now, Mr Reid, don't be distracted by any of my questions about procedural matters, and we can deal with that this afternoon, in particular after you've had a chance to talk to Mr Coxon. Mr Armstrong, about anything that's concerning you?
Yes. Thank you, Your Honour. I make application to amend the defence according to the document that's been filed.
Yes, I take it, Mr Armstrong, there is no objection, as I've been informed, and I will make the order.
Please. Your Honour, the summer of 2012-13 was a season of extreme fire danger. If document 130 could be brought up, Bates number 328. Your Honour will see from the first page of that document, it's a submission from the Tasmania Fire Service to the Bushfire inquiry. And at 328, if we scroll down, we will find 1.3, the events. And there, Your Honour, significant fires start on Thursday, the 3rd of January, and they're named as Lake Repulse, Fawcett, Middle Trees, Tea Tree Road, plus 49 others. The township of Richmond was threatened and defended, and Lake Repulse and Fawcett developed into major incidents. Your Honour, there were, I think this might be on the next page if we scroll down. No, it's not on that page. There was 900 odd fires in about a 3-month period is what the document discloses. So point of that, Your Honour, is that clearly the investigative workload for the TFS was extreme, and it could not reasonably be expected that a complete investigation would be conducted by a skilled investigator of each fire. The evidence to be presented by the defence at this trial indicates that at about 1:30, or possibly earlier, a fire started in an area known as Inala Park. This is at the general northerly end of Inala Road. We say that it is this fire which caused the harm to the test plaintiff. That is, it is this fire that hit Dunalley on the 4th of January. This fire was never investigated by the TFS, or indeed anyone, at its area of origin, i.e. Inala Park. Now, we don't put that critically, Your Honour, because of the extreme difficulties of all fires, but it's a fact, it wasn't. there was no investigation conducted by any investigator of the area within Dunalley Park. We say that a second fire in time started at 242 Whitehill Road, the property owned by the first defendant. And the plaintiff pleads paragraph 12 of the statement of claim that that fire started about 2 p.m.
What protocol are we going to use for time? We're going to use 2:15 p.m. because I think once we get into the O calls, we'll be looking at 1400.
Yes, we will be. Yes.
I don't mind. Interchangeable is fine by me.
It will certainly suit me if it's interchangeable, Your Honour.
Right. Mr. Armstrong, you happy with that?
Suits me as well, Your Honour.
Thank you, Your Honour. And that's where we next go, Your Honour, to the O calls. If document 76 could be brought up, Bates number 301, and it will need to be turned around so that we can see it. Now, if Your Honour goes into this document, it would appear that the first call relating to any fire in the Fawcett area, so I'm including in that description Whitehill Road and Dunalley Park, the first call was made by Mr. Damien John Berry.
Sorry, this is document 299. Yep.
Document
No, 0299.
Moment. Okay, I needed 301 up.
Yeah. No, it is 301, but
It's document 76.
document 76.
Yeah, document 76.
Number. Yeah.
301. Yes.
Thank you.
Yeah, which was the one that was on the screen. Your Honour, just...
Yep.
While that's coming up, Your Honour, my opening may be a little clunky, and the reason, in reference to the documents, the reason for that is that the Mac version of the court book is still not fully on my machine.
Right.
I've been doing catch-up, and I'm reasonably happy that after lunch I'll be running a bit more smoothly, but I apologise in advance.
I couldn't expect you to betray your long-standing loyalty, Mr. Fred Apple.
It's lucky I'm not good at hearing, Your Honour. Your Honour, the first call that appears to have been made is from Damien John Berry at 14:12:57. Now, this document reads from the bottom up. Whoops, it's just been moved again.
14:12:57.
Yes, 14:12:57, and that the evidence will probably indicate is a report of a fire at 242 at Barrett's property.
Right.
Sorry, if the operator could stop moving the document, please.
Yeah.
Now, we then move upwards from there, and we find a call from Melissa Barrett at 14:32, which is also, as you might expect, Your Honour, a report of a fire at 242.
14:23:59.
No, 14:32.
That must have been the second call, wasn't it?
The first call was Damien Berry at 14:12.
No,
the next call is Barrett at 14:14.
Ms. Barrett phoned twice.
Yes, she did, and she phones again at 14:23, which is the second call, her second call. The document runs from time-wise from the bottom to the top.
Yep, so 14:32 is the first call, is that what you're saying?
That's Barrett's first call, yes.
Just let me get that.
Yeah.
Yes, thank you.
Yeah, I'll just go back one, Your Honour. The first call in relation to 242 is 14:12:57 from Berry.
That's Mr. Berry.
Then you've got Barrett And then we go up to Sutcliffe Ann, 14/15/31. And that, the evidence will indicate, is to report the fire at Inala Road. Now, there are other reports, and Your Honour's gone to the next Barrett call of 14/23, but they're not relevant for my present.
And these critical ones are identified in your opening, your written opening, I think.
I think they are, Your Honour. Yes. Your Honour, I'm sorry, I can't bring that to mind.
No, I'm sure they are, but I've taken a note of them now.
Yes,
so.
yes. Now, we say this, that the fire which was observed at Inala Road and led to the call from Mrs Sutcliffe was a fire about 850 metres to the east, perhaps southeast, of Barrett's property. And it is possible, Your Honour, to get exact distances by use of, or very close distances by use of Pythagoras' theory and the TAS maps, and we'll be providing some information in relation to that so that these distances become a bit more than just assertions. The wind was blowing from the west, and there's no question about that between the parties as it sees. Now, we do not suggest that the fire that was seen at Inala Road was responsible for the 242 Whitehill Road fire. We do not suggest that. That would be to suggest that somehow the fire blew backwards.
Against the wind.
Against the wind for 850 metres. So that is not the suggestion. The proposition this defence puts is that these fires were unconnected at all times. Now, once the fire was established in Inala Road, it took off to the east. The fire at 242 ran to the southeast, but as my learned friend has said, it hit a previously burnt area south, generally south of 244 Whitehill Road, which slowed its progress. And we say that by the time it got to Inala Road, the Inala Road fire had long gone.
What do you mean long gone?
Taken off to the east.
Yes.
Yes. Probably more correctly, the head of the fire had long gone.
Yeah.
Yeah. Yes. Now, this can be illustrated by a very helpful map prepared by the plaintiff's expert, Dr. Marsden Smedley.
So just to be sure that I understand you, are you saying that the
Whitehill Road?
The Whitehill Road fire was then burning behind the Inala Road fire?
Yes.
Yes, I see.
Mm. Yes. Insofar as it could burn behind it, because the flammable, combustible material was by that stage limited.
Right, so you say the Whitehill Road fire then was not relevant after the time at which the Inala Road fire took off, as you put it.
That's it, Your Honour. That's the proposition.
Right.
And that in the legal formulation, of course, takes us into section 13(1)(a), and it can be asked this way: was the Inala Road fire a necessary element of the harm to the test plaintiff? Now, this can be illustrated, Your Honour, if we get document 126, page number 647 up. This is a report that we received, I think, at 10:59 p.m. on Sunday night, from a fourth report from Dr. Marsden Smedley. My reference to it should not be taken as a tender of it, Your Honour. If we go back to the previous page, please, Your Honour will see that what Dr. Marsden Smedley has done is that he has put in various bits of information, and he puts in an ignition point of 242 Whitehill Road, and that's a very common, you'll see that very commonly throughout a lot of documents in this case. And then you'll see the next one, faucet fire at 3 o'clock. Now if we go to the next page, Your Honour, you'll see that that 2 is a relatively small area close to point 1, the ignition point. And it's the opinion of Dr. Marsden-Smedley, held consistently, that by 3 p.m. the Whitehill Road fire had moved 230 metres in a general easterly direction with an area of 2.5 hectares. And that is what that shows.
And was contained to that.
At 3 o'clock, that's where it was, yes. Not, in terms of the word contained, we're not suggesting that it was fought at that.
No.
But that was its size. That's his expert opinion. Now, if we go back to the previous page, we'll see some names: 6, 7, 8, 11 and 12. And the names are not important, Your Honour, but if we go back to the map and have a look at where they are, 6, you can see 8, 9, 7 and 11. Now, number 11, Your Honour, sees a fire probably 1:30, sees flames probably 1:30 in front of him. So if looking east, he's looking east towards the property. The property where those 2 stars, 9 and 6 are, is 112 Inala Road, and flames are seen between number 11 and 112 in the order of 1:30, 1:45.
So 11 and 12? I thought you said 112.
No, sorry, 112 is not on the map, Your Honour. 112 is the house that sits beneath stars 9 and 6.
And it's simply not on the map.
No, it's not on the map. You'll see Inala Road, Your Honour.
How far underneath? Is it further than the numeral 7?
Oh no, Your Honour, if you lifted the 9 and the 6 off the map, if you rub them out, you'd be able to see the house. Yeah. So number 11 is looking towards the house and sees flames. We just go back so I can identify who. You can have a look for number 8 on the next page, please. Number 8 will give evidence. He's a volunteer firefighter. He will give evidence that he saw flames about an hour later and a considerably burnt out area between where 8 and 11 are, if triangulated, between 8 and 11 and the house at 112. So his evidence at 2:40, he sees a fire there, remembering that at 3 o'clock, the expert evidence presented by the plaintiff says the fire hasn't gone anywhere near there. If the evidence of witness number 11 is accepted, the fire hasn't even started.
Which fire?
The fire at 2:42 hasn't even started when he sees the fire that we say occurred at Inala Road.
You're going to have to stop using 242.
The Barrett fire,
Yes,
I'll call it.
I think so, because...
Yes.
So before the Barrett fire had even started?
Yes. Fire is seen in Inala Park, if that evidence is accepted.
Just while you're pausing, shall I take it, Mr Armstrong, that nothing you referred to in your opening address was intended to be by way of tender?
Actually, Your Honour, the photographs that I referred to the meteorological records, the declarations of fire ban and fire permit, and the photographs I was proposing.
Well, let me know after lunch if there was anything that you referred to that you didn't propose to tender.
Thank you, Your Honour.
Thank you. Sorry, Mr. Reid, but
Yes.
carved out
Yeah.
of the protocol, and I need to make sure that
Yes.
we've got it across the board.
Well, and so do I, Your Honour. I'm not sure as to the status of the protocol, and I need to check that with my friend at lunchtime. But, I can say that I certainly intend to tender the 000 records, and but I won't do it now because may well mess up any numbering system.
Well, I may not accept their tender as a job lot, so
Yes.
we'll have to work that out as we go along.
Yes.
But so far, I'm content to you've been identifying 000 calls in your opening, and to the extent that you have, they're tendered.
Yes, that's certainly my intention. Your Honour.
Thank you. So it was only the Marsden-Smedley report that you didn't wish to tender at this stage.
At this stage, yes.
Thank you.
Yes. Now, Your Honour, at the view tomorrow, it's obviously our intention to ask that you go to Anala Park, to the area of the property at 112 Anala Road. So that's one of the points of view.
Is that on the list at the moment?
It is. It is. Yes.
So what's the point you make? Just that I'll get a look at it.
You'll get a look at it.
Yes.
Yes. You'll get a look at it. You'll get a sense of the terrain.
And you can explain to me where 6 and 9 and 112 are.
Yes, and that I'll do at the view. It's also intended, Your Honour, to take you to Gangels Road, which is further to the east.
And that was one of the other calls in.
There will be evidence. No, that's not one of the calls I've referred to, Your Honour. There'll be evidence about when the fire reached Gangels Road.
I see. Yes.
And we say that evidence, coupled with Dr. Marsden-Smedley's expert evidence, shows that it could not be the Barrett fire which got to Gangels Road.
Well, all right. Well, at the highest level of abstraction, what do you say happened to the Barrett fire?
The Barrett fire got to the previously burnt out area of 244, and I haven't even opened that. I'll tell
That's
you about
Inala Road. Let's.
No, sorry. If Your Honour looks at the photograph we've got up at the moment, this isn't at the highest level of abstraction. It's going to have some detail, but
Fairly granular, I would have thought.
yes, it is. Well, no, I didn't mean the photograph. But Your Honour will see a patch of greenery in the top centre.
Number 4.
Yes. Now that is the evidence will indicate an area that was burnt in October of the previous year, and my learned friend opened in relation to it, and we don't disagree with him that when the Barrett fire got to it, it would slow down because the burning the combustible material had already been contained by that fire.
So I didn't go beyond there. That's at the highest level of abstraction.
Yes.
It just burnt out.
Yes, yes. And it didn't go beyond 112 because that had been burnt out. It didn't go east of 112 because that had been burnt out by the fire that the witnesses saw. That's the level of abstraction, Your Honour. So there are two things to it.
It was contained by
natural elements, really.
Well, by the regrowth in one area and the burning out caused by the fire you say is the original fire.
That's it, Your Honour.
Or the subject of the fire that's responsible for the damage.
Yes, that's so, Your Honour. Now, so we will also be taking you to identify number 7 on that map, Your Honour, because that is a witness will give evidence of when she saw fire from that residence, which is also important to the timeline of all this.
Have you prepared a chronology in respect of this for your own purposes?
Many, Your Honour, yes. Yeah. Yes.
Might be useful to give some thought to one prior to closing addresses.
Yes. Oh, we'll certainly do that, Your Honour.
Connect the dots.
Yes, yes. So, Your Honour, that's the key causal point, but it goes further than that. And if, Your Honour, if document 132 could be brought up, it's the most recently amended statement of claim. And if we could go to paragraph 12 of it. Now, on our way to paragraph 12, Your Honour will see there's no issue that the campfire was lit on the Barrett property.
Mm-hmm.
Equally, there's no issue as to duty, as was previously discussed. But paragraph 12 and 13 are, in our submission, key paragraphs. At around 2 o'clock, an assertion that we don't disagree with, the smouldering burn in the tree stump and its root system ignited grass on the surface of the ground in the immediate area around the tree stump. Particulars. The point of origin of the fire was identified as an area approximately 2.6 metres south-southeast of the tree stump. Your Honour was shown some pictures of an excavation that is clearly to the northwest of the tree stump, but the particularisation of this fire is that it was, the area lit was approximately 2.6 metres south-southeast of the tree stump. Now, our case in relation to this plea is that it runs into 4 significant, and we say insurmountable, hurdles. And they are, Your Honour, I'll give them to you and then I'll come and address them individually. They are, first of all, the observations made by Barrett when she first saw fire.
Mm-hmm.
The second is what we say is the likely finding that the route identified by the TFS investigators was not connected to the old stump.
Mm-hmm.
And therefore it couldn't have been smouldering by reason of the campfire. The third is the opinion formed by the TFS investigator, Mr. Bones, on the 5th, Saturday the 5th of January. And the fourth is the lack of any expert explanation to link the pleaded point of origin with the heat source relied on. Now, as to those 4, first of all, Barrett's observations. You'll see that at paragraph 13, it's pleaded that between 2 and 2:15 on the 3rd, Barrett saw grass on the surface of the ground in the immediate area around the tree stump on fire. That is denied, and the evidence does not support that. In her interview with police on the evening of the 5th, Barrett describes her observations when she first saw the fire. So what happened chronologically on the 5th, that's the Saturday, the fire starting on the Thursday. On the 5th, police and TFS investigators arrived at the Barrett property at about 4:30 in the afternoon. And at some stage after that, Barrett and the second defendant were taken to the Sorrel police station for interview. And the TFS investigators remained and continued the investigation. In her interview with police on the evening of the 5th, Barrett describes her observations when she first saw the fire. If document 52, page 35 could be brought up, please. Now, you could just start at the top of the page so I can identify the portion. Page excuse me, page 35, please. Sorry, Bates numbering 35, thank you. Now, all I did was looked at that side. Fire was on that side. I didn't look there. Now, that it will transpire as evidence that encompasses this. Barrett's been inside to get a cup of tea or coffee and get a cigarette that is not yet lit, and she's come out onto the deck that you've seen in the photograph, and she's looked east. And she says, I looked at the fire was on that side. And if we can scroll down, please. So you're indicating you looked to the left, the fire was on your right, yep. And then I went back inside and grabbed my things, waiting for the kettle to boil. Went out on the deck, went to light the cigarette. That's when I saw everything on fire. Can you tell me what you saw? That's right, because I remember I thought I went out. Your Honour, when Your Honour hears from Ms Barrett, will understand that she's a fairly garrulous lady, and this interview is not short on words as a result. If we can continue down, she says, I looked to the right and saw both my property on both sides of, and I'll leave out the ums and ahs, the little flat sort of driveway on fire. That was already on fire. And she says, we say significantly, it wasn't a spot fire. It wasn't a spot fire. So it wasn't like you were watching it start out. It was established, is the question. No, it was established very quickly. All right. Can you tell us from your balcony where you were standing, how far in metres was the flame? How far was it in metres? And Your Honour will, I would expect, reach the conclusion that Ms Barrett has absolutely no idea of distance, but we'll see where that goes. But she says, I will say it wasn't at the stump. Now that's the first interview. She says two things of importance in relation to this plea at paragraph 13 of the Statement of Claim. First of all, it wasn't a spot, and secondly, it wasn't at the stump. She continues on, it was back from the stump. We can scroll down. And then perhaps the leading question is looking down towards your driveway that you come up, if you entered the property at the top, yep, you're saying the stump's to the right of the driveway, yes, and then how many metres, or would that be 10 metres away, and we know it's probably 30, and she says that'd be a guess, and then, so you come out, you look towards the stump. I've looked at the stump, I've looked beyond the stump, and I've seen, as I said, that flat driveway. I've seen a wall of little flames, and they weren't red, they looked more orangey, they looked more yellow. They weren't a red. Okay, red flame could have been because you know it was so bright and that, you know, everything's really bright, and she then describes it as a long flame. If we can continue to scroll down, talks about trees, and she says, we just need to continue through this, might be the easiest way to go, probably about 3 metres. And if we can just drop down a little bit further, no, other way please. Yep, thank you. So you're saying a wall now, there's obviously a driveway that comes up. So it was just on one side of the driveway, both sides at the same time. Can just go above that for a moment. Now we go down, please. Each fire was about 5 metres in width each. She's talking there apparently about a fire on either side of her driveway at that stage. And she describes that. And the one on the right-hand side was 5, the one on the left-hand side was 5. And if we can continue. And then Just stay there, please. Just go up a little bit. This is all discussion about driveway. We can continue to go down. The end of it, and Your Honour will hear it this afternoon rather than try to find the passage, is that she gives very clear evidence that it's creeping back towards the stump at the time. Now, the next day, Your Honour, she's interviewed she speaks with the Tasmanian Fire Service investigators, Bones and Johnson. And she draws on the ground 2 pink lines that Your Honour was taken to.
The first pink line was above the stump, wasn't it?
No, Your Honour.
Both below.
Both lines are to the east of the stump.
Yes.
And the evidence would indicate that she drew the first one closer to the stump and then reconsidered it and said it's further away. Now, what she didn't tell the investigators on that day, or what is not recorded, and I should say that that Mr. Bones in his report says that she was interviewed, but there's no transcript of any interview and no contemporaneous notes. So we say, well, there might have been a chat. There is no record from Bones that he was told by Barrett that the fire was creeping back towards the stump. That had clearly been said in the interview the night before, and the next day, what Bones records in his report is that she noticed fire in an area that would be approximately 5 to 15 metres in a direction from the old stump. Now, Bones may have assumed that the fire she saw was going east. But she'd told the police the night before very clearly that it was coming towards the stump when she first saw it. And when she's interviewed the next day, again by the police, and this interview is recorded, if we go to document 58, page 171, she's describing that. I just saw the flames going between this little unflat driveway, and I've got a little sort of old daggy bit of driveway on that side, which is the right side. You'll probably see, and Your Honour may well be able to see that that daggy bit of driveway. We will be able to see the daggy bit of driveway. It's quite daggy. She's then describing the furthest pink line, and she says there were naked flames because it was quite dry. It was pretty much dry grass. So that's flames. And at the same time, it was creeping back over that pink line, coming this way towards the house.
Over the pink far line.
Sorry, yes, thank you, the pink far line. Yes. Yep. So we say that if Barrett is accepted, that she first saw the fire east of the pink far line and it was creeping towards her, the plea made at paragraphs 12 and 13 as to cause cannot be made out. Now, there's a green arrow shown, in fact, I think Your Honour might have referred to as a yellow arrow, shown heading in an easterly direction rather, between the 2 pink lines. The evidence will be that that line was not drawn by Barrett, and she doesn't know what it is, what it depicts.
Which line doesn't she?
The arrow. The arrow. Not her work, and she doesn't know about it. Now, there's one other matter in relation to Barrett's observations that it might be convenient to deal with before we break for lunch. And the second is that what Barrett saw was a line of fire extending on effectively a northern line, south-north or north-south, whichever way it goes. It's parallel to the eastern edge of her house. Now, it was an oblong shape, burning across her field of view, not away from her. If the fire had commenced as pleaded at the stump, it would be expected that the shape of what was seen by her would be long and thin, extending away from her. The reason for that, Your Honour, is that what is pleaded by the plaintiffs is a grass fire. And grass fires, when taken by the wind, form a cigar shape. It then got into the trees and different things occurred. But what was seen by Barrett, the shape of what she saw, is inconsistent with a grass fire taking off from the area of the stump. That may be a convenient time, Your Honour.
Yes, I'll just take a moment to note that. Thank you. The court will adjourn until 2:15.
Please stand, please. This honourable court now stands adjourned until 2:15 p.m.